Welcome to INN's Student. INN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Prathamesh Mishra. He is going to speak on brief overview of Indian Divorce Act 2001. He is from KES Shri Jayantilal Age Patel College of Law. So without wasting further time, I would request him to commence with his lecture. Thank you.
Greetings to everyone. I am Prathamesh Mishra, the student of KES Shri Jayantilal H. Patel Law College. The topic I will be covering today is Indian Divorce Act 2001. The Indian Divorce Act 2001 is an amendment for India's family law framework. Marriage is often seen as sacred institution, but with the time, there are chances that it may not succeed due to incompatibility or personal differences. The law relating to divorce are therefore necessary to balance individual or liberty, gender, justice and social order. The Indian Divorce Act particularly deals with the Christians in India, and it is 2001 amendment which modernized the provisions that were originally laid down in 19th century. So now before going ahead, let's understand the background of the act. The Indian Divorce Act 1869 was the first codified law governing divorce among Christians in India. It was largely modeled on English matrimonial law of that period. However, the 1869 Act was highly conservative and discriminatory in nature. It allowed the husband to seek divorce solely on the ground of adultery. On the other hand, wives could only seek divorce if adultery was combined with the cruelty, desertion, or certain serious factors. As a result, the Indian Divorce Act 1869 came under strong criticism for being gender biased and outdated, especially as society evolved and equality principles developed after India's independence. Now let's understand the purpose behind the amendment of the Act. The Indian Divorce Act 2001 was introduced to correct these inequalities and bring the law in line with the constitutional principles. There were some key purposes for amendment such as equality on grounds. Equality of grounds, it removed the distinction between men and women. Now both husband and wife can file for divorce on similar grounds such as adultery, cruelty, desertion, conversion to another religion, unsoundness of mind, or not being heard for 7 years. Introduction to mutual consent. It was the first time that Christian couples could seek divorce by mutual consent after 2 years of separation, which later reduced to 1 year in a line with the other personal reason. Simplification of procedure. It made the legal process more humane and less burdensome. The main objective was to ensure fairness and gender justice and quick resolution of matrimonial disputes within the Christian community. The Indian Divorce Act 2001 had impacted the significant aspects of various fields like social and legal fields. Gender justice. Women now enjoy equal rights with the men to seek divorce. This was a big step towards the constitutional equality under the Article 14 and 15 of the Indian Constitution. Relief to couples. The provision of mutual consent divorce recognized that the sometimes marriage fail without fault of either of the parties. Modernization. It brought Christian personal law close to other laws in India like Hindu Marriage Act 1955 and Special Marriage Act 1954. The judicial approach. Courts may have become more progressive in interrupting matrimonial disputes. Judicial approach. Courts have become more progressive in interpreting matrimonial disputes and granting relief to aggrieved spouses. Let's understand the case law related to Indian Divorce Act 2001. Mary George versus Sonny George. Mrs. Mary George filed an application under the section 10 and 22 of the Indian Divorce Act 1869 alleging the cruelty on the part of her husband, that is Sonny George. Marriage took place on 27th November 1989 at Mary's Orthodox Church in Kerala according to prevalent Christian marriage rites and customs. Although the district judge of the Bhopal tried the matter, respondent did not appear to contest the application. Consequently, same has been allowed by order dated on 22nd Feb 2001, decree of divorce has been passed. However, in terms of section 17 of the act, it is referred to High Court for the confirmation. During the course of hearing, it was found that the Indian Divorce Act 1869 has been amended by the Indian Divorce Act 2001. Subsection 2 of section 1 of the amended act provides for coming into force of Indian Divorce Act on such date as the central government may by notification in the official gazette appoint notification by Ministry of Law, Justice and Company Affairs dated on 3rd October 2001, published in the Gazette of the Indian Part 2 Section 3 of subsection 2 appoints 3rd October 2001 as the date on which the act should come into force. The result is that the High Court loses its jurisdiction under 17 of the Act for confirmation of the order passed by the district judge under section 10 and 22 of the Act. The question is whether the amendment would apply to pending proceedings or not. The question should not detain us from law for long, since section 10 of the amended Act 2001 provides for dissolution of marriage solemnized before or after the commencement of the Indian Divorce Act 2001 on a petition presented to district court either by the husband or wife or on any ground mentioned therein. Under the old provision, the decree for divorce could only sought on proof of adultery with cruelty. Otherwise, for cruelty alone, judicial separation could be ordered. That's it. The Amendment Act gives the right to the spouse to seek divorce on the ground that he or she had been treated with such cruelty or to cause reasonable apprehension in his or her mind that it would be harmful or injurious for him or her to live with the other partner. The order passed by the district judge has no force till it is confirmed by High Court under the old Act. Therefore, proceedings are taken to be pending on commencement of the Amendment Act 2001. Consequently, matter is remanded to District Judge Bhopal for disposal in accordance with the law at the earliest. To conclude, the Indian Divorce Act 2001, as it was a landmark reform in India's matrimonial law framework for Christians, it corrected the injustice of the Act 1869, especially the gender bias, and it also acknowledged the modern realities by including divorce by mutual consent, by harmonizing personal laws with the constitutional guarantees of equality and dignity. It strengthened the individual rights which respects the community traditions. The act is not just about ending the marriage but about ensuring fairness when relationship break down. In that sense, it represents the balance between the tradition, justice and the evolving values of the Indian society. Thank you.
Prathamesh, thank you very much.
Thank you, sir.
We could see that it was a nicely researched topic you have said, because you have mentioned various gazettes, the amendment of 2001. So thank you very much for this.
Thank you,
A small token from Hammurabi to you.
Thank you.